Hi, my name is Katie Dwight, and I'm here with Becca von Baron, and we are lawyers at Swords to Plowshares. Swords to Plowshares is a veteran service organization that provides a range of benefits to veterans. In addition to legal benefits, advocacy, Swords to Plowshares has employment and training services, case management for homeless and low-income veterans, and housing, both permanent and transitional. We're going to be doing a webinar today about VA presumptions. So we'll go right into it. Becca is going to start us off.
Hello. So I'm going to talk about VA presumptions. So first of all, what is a presumption for VA purposes? So when the VA designates a disease or a condition as presumptively service-connected, it means that a veteran does not have to prove that the disease was incurred in service. The VA will assume it was. So the veteran doesn't have to have the evidence to prove it. It will just be presumptively service-connected. Now, presumptions are rebuttable by the VA, and that's where there is affirmative evidence to the contrary, or evidence that establishes that an intercurrent injury or disease was the cause of the condition, or if the condition is a result of the veteran's own willful misconduct. So that could be, an example of that could be if a veteran has a, this wouldn't be a presumptive condition, but a traumatic brain injury, and it's the result of a car accident where the veteran was using substances. That's an example of an injury that's the result of a veteran's willful misconduct. But again, a traumatic brain injury, there's no presumptive connection for TBIs. So I'm going to talk for a little bit about Gulf War presumptions. And you'll usually hear these conditions referred to as Gulf War syndrome or Gulf War illness. Now, the VA no longer uses those terms because the symptoms that are encapsulated by those terms are too varied to fall into just one category. So instead, the VA refers to the conditions as chronic multi-syndrome illness or simply undiagnosed illness. But I will refer from time to time to the conditions as Gulf War syndrome. Now, the Gulf War presumptive rules apply to Operation Desert Shield and Desert Storm, Operation Enduring Freedom, and Operation Iraqi Freedom. And you might have heard of the last two referred to as the Global War on Terrorism. Now, there are three requirements for the presumptive service connection for Gulf War veterans. And first, you have to qualify as a Gulf War veteran, and we'll get into what that means in just a moment. And second, you must suffer from a qualifying chronic disability. And third, the disability must have become manifest to a degree of at least 10% at any time from service to the present. Now, there are some limitations, and those are if there was an intervening event that caused the disability, you do not get the presumptive benefit. The disability was not incurred during service, or the disability is a result of willful misconduct or the abuse of alcohol or drugs. Now, as I said, we're going to talk a little bit about what a qualifying Gulf War veteran means. Now, for this, you must have served in Southwest Asia during the Gulf Wars. and that includes service in Iraq, Kuwait, Saudi Arabia, Bahrain, Qatar, United Arab Emirates, Oman, the Gulf of Aden, Gulf of Oman, the Persian Gulf, the Arabian Sea, the Red Sea, and the airspace above these locations. And additionally, your service must have been after August 2nd, 1990. So those are the veterans who qualify, who can get in the gates to even be veterans who can have the benefit of these presumptive rules. Now, what are the qualifying disabilities that receive the presumptive rules? Now, first, as you'll see at the top, the word chronic, and we'll talk about that in a second. But you must have a chronic disability that's the result of an undiagnosed illness. And this is a medically unexplained, and that's actually a different category than a medically unexplained chronic multi-symptom illness that is defined by a cluster of signs. And some examples of those signs are chronic fatigue syndrome, fibromyalgia, and most functional gastrointestinal disorders. And it's a little confusing, the distinction between what is an undiagnosed illness and what is a medically unexplained chronic multi-symptom illness. You'll see some overlapping as we go over this in sort of the symptoms and signs that indicate one or the other. But you can see the similarities in both, that it's something that the VA can't quite identify exactly what it is, and it's defined by its symptoms rather than a named condition that is known. And then any diagnosed illness that the VA determines warrants a presumption will also be included in the conditions that receive the presumptive rules for Gulf War veterans. Now, some symptoms of an undiagnosed or medically unexplained chronic multi-symptom illness are weight loss, fatigue, gastrointestinal symptoms, headache, joint pain, menstrual disorders, muscle pain. There can be neurological symptoms, skin rashes or other skin disorders, respiratory problems, and sleep disturbances. Now, so these things will come together in a way that they don't match up to a diagnosis that is known. So it'll be someone who, a Gulf War veteran who presents with these symptoms, but the medical clinician cannot diagnose what all these symptoms add up to be. And this is a really unique thing within VA rules, but lay evidence can actually be used to establish these symptoms. So you don't have to have medical evidence that you have these symptoms. A veteran's lay statement can be used to establish through a letter from buddy letters, a letter from somebody that you spend a great deal of time with and has witnessed these symptoms. Those sorts of things can be used to establish that the Gulf War veteran does in fact have weight loss, joint pain, skin rashes, etc. And as I said, some examples are chronic fatigue syndrome, most functional gastrointestinal disorders, and fibromyalgia. Now, what is meant by chronic? It's very different than what we usually think of as chronic. And in this definition, the disability must have persisted for a period of 6 months or more. And it's important to note that even if the disability has intermittent episodes of improvement within the 6-month period, it is still considered chronic. So you can have intermittent periods of intense fatigue, weight fluctuation, muscle pain that comes and goes, but as long as that goes on for a period of 6 months or more, that will be considered chronic. So don't get tripped up on the word chronic, because it really does have a different sort of definition in this context than the way we usually think of the word chronic. And it's important to remember when you're looking through medical records, when you're claiming the disability, that an undiagnosed illness and a chronic multi-symptom illness are different categories. So let's talk about what a chronic multi-symptom illness is. It's an undiagnosed, it's a diagnosed illness without conclusive pathology or etiology that is characterized by overlapping symptoms and signs and has features such as fatigue, pain, and a disability out of proportion to physical findings and inconsistent laboratory findings. So as you'll see, some of the signs and symptoms overlap, the fatigue, the pain, etc. And this also must be chronic. Now, presumptive service connection can also be established for 9 different infectious diseases that are associated with service in Southwest Asia. And the presumptive time period in which each disease must have manifested varies by the disease. So for example, malaria must have manifested to a degree of 10% or more within 1 year of the veteran's service in Southwest Asia. Now I just want to point one thing out here, that the fact that these conditions must have manifested to a degree of 10% or more, although that seems like a very small percentage, you're often talking about clusters of symptoms or things that become compounded, and often many of these Gulf War veterans have one or more of these conditions. So it really comes together to be a lot of disabilities or signs or symptoms that are compounded to create a great deal of problems for Gulf War veterans. So you may see the 10% and say, oh, that's not that bad, but they really become quite serious when they're taken together in concert. Now the VA has identified several conditions as associated with the 9 presumptive infectious diseases. So you may have one of the infectious diseases, but the VA has recognized that there are secondary conditions that are incredibly common to come out of those 9 infectious diseases, but they're not as lenient as you hope they would be, in the sense that if a veteran is diagnosed with one of those associated conditions, they still must get a medical nexus statement, meaning they must get a doctor to issue a statement saying it is as likely as not that the associated condition was caused by the presumptive condition before they'll concede service connection. So that's something that would hopefully be included within the presumptive rules, but is unfortunately not. Now, one thing that has caused a lot of problems for veterans who served in Southwest Asia or who are serving in Southwest Asia are burn pits. And these are large burn piles where the military is disposed of an incredible amount of waste material. Now, these burn pits are located at every forward operating base. And right now, there are no presumptive rules for conditions that result from burn pit exposure, but the VA has begun to acknowledge an association with respiratory, cardiopulmonary, neurological, autoimmune, and skin disorders. And this has taken the VA quite a while, actually, to even concede this much. And even so, despite the amount of studies that are out about the effects of exposure to burn pits, as far as the VA has gone is to set up burn pit registries where they encourage veterans to register if they believe they were exposed to burn pits and track their symptoms. And this is so the VA can have you know, long-term evidence of what symptoms may or may not be associated with exposure to burn pits, through data collected from veterans who were in Southwest Asia using empirical data. And it seems sort of like a setup for the same kind of treatment that Agent Orange exposed veterans have now received. So hopefully we'll see some presumptive rules coming out of that, but surely we don't hope that it takes 40 years for that to happen. But there is some progress being made because of the widespread nature of the burn pits and the inability of military personnel records to identify all duty locations. The VA is accepting veterans' lay statements of burn pit exposure as sufficient to establish the occurrence of such exposure, especially if the veteran served in Iraq, Afghanistan, or Djibouti. Now, the most widely publicized burn pit was at Joint Base Balad, and that base is also known as Logistics Support Area Anaconda. It's located in northern Iraq, approximately 68 kilometers north of Baghdad and 1.5 kilometers from the Tigris River. And that's important because burn pits also create particulate matter, which we'll talk about in a minute, but that going into water can be especially problematic. Now, the base occupies 25 square kilometers, and the burn pit itself covers 10 acres. And according to the U.S. Army Center for Health Promotion and Preventative Medicine, the amount of solid waste burned at Balad was estimated at about 2 tons of material per day in the early stages of troop deployment, and increased up to several hundred tons per day. And they actually used jet fuel as the accelerant. And the air base is home to approximately 25,000 military, civilian, and coalition personnel. So you're talking about exposure and associated diseases and symptoms for a really large amount of people. And currently, the VA claims it's not able to determine what the possible adverse health effects might be caused by the high levels of particulate matter, numerous toxic organic halogenated dioxins and furans, and the known and unknown polycyclic aromatic hydrocarbons, and also volatile organic compounds that have been created by the burn pits. And I just found this staggering. For example, the 22 of the toxins found released by the burn pits, and this is not including the dioxins and particulate matter, adversely affect the respiratory system. And this is known. At least 20 affect the skin, at least 12 affect the eyes, and many others affect the liver, kidneys, central nervous system, cardiovascular system, reproductive system, peripheral nervous system, and GI tract. And this is known through multiple studies, but the VA, as I have said, has still not conceded that the effects are known. In at least 7 of the toxins, dermal contact can significantly contribute to overall exposure. And many of the troops have actually ingested amounts of these toxins through food sources because the smoke plumes disperse the particulate matter through the base facilities. Now, here's a sense of what the VA has done, which is progress. The VA has advised regional office personnel to be aware that many veterans that suffer from illnesses such as respiratory, cardiopulmonary, neurological, autoimmune, and or skin disorders may not know that those conditions can be associated with burn pit exposure, especially because a lot of veterans, while they were in service, experienced those conditions and symptoms on a regular basis. Further, if the veteran identifies in any way burn pit exposure in a disability claim, the raters must actively review their claims by recognizing potential exposure issues whenever they're reasonably raised by the record, and then develop those claims in accordance with special instructions on exposure to burn pits. And raters have also been advised to consider claims based on burn pit exposure in a broad and liberal manner. So this is an area that, as advocates, we should really be keeping our eye on in terms of presumptive conditions that may arise from exposure to burn pits. Now, particulate matter is caused by burn pits, dust storms, and local industry. And this is associated with heart and lung disorders and just a huge range of conditions and symptoms. Now, importantly, the VA does provide fact sheets to compensation and pension examiners in order to educate them about where particulate matter may be a factor in a veteran's condition. And when a veteran makes a claim about exposure to burn pits, or they're not necessarily going to say they're exposed to particulate matter, but certainly burn pits, the raters have been told to really pay attention to post-deployment health assessments and discharge examinations that are in a veteran service treatment records, and that's something that also really needs to be highlighted in a claim, because there are check boxes, especially on the post-deployment health assessment, where a veteran can identify if they were exposed to burn pits, and they actually ask in a number of ways to get at the question of whether or not there was exposure. And military service records won't verify all instances or really any instances of exposure. So the VA does accept alternative evidence such as personal statements, buddy statements, unit histories, or even news articles that you know, a veteran can present evidence from their personnel records showing they were located at a certain place and match it up with a news article that mentions that there was a burn pit at that location, and use that to corroborate exposure to particulate matter, or really any lay evidence they can find to corroborate that they were in a location where there was exposure to burn pits or particulate matter. And exposure may be verified or conceded if the statements provided by the veteran and or others are consistent with the facts, places, and circumstances of the veteran's service. Now, because burn pits and dust storms and local industry is so pervasive in these areas, that won't be a difficult burden to get over, that exposure is consistent with the facts, places, and circumstances of the veteran's service. And the VA is aware, primarily through cooperation with the Department of Defense, of the extent of potentially hazardous exposures. For example, elevated particulate matter levels throughout Iraq, Afghanistan, Djibouti, as well as burn pits located at all military forward operating bases in those same regions. So especially for those areas, if you can show really any presence there with even a minimal amount of lay evidence, exposure will probably be conceded. Now, another, something else that's linked to Gulf War illness and the signs and symptoms of undiagnosed illness and multi-symptom illness is pyridostigmine. My apologies for not being able to pronounce correctly that word, bromide, or PB. And PB is given to troops for protection against chemical warfare, but actually has effects that can cause Gulf War illness. And in a study conducted by the U.S. Army Medical Research and Material Command, PB was found to affect people differently depending on their genes. And those with a gene producing weaker forms of the enzyme, again, apologies, acetylcholinesterase, were 40 times more likely to contract Gulf War illness than those not receiving PB. And those with a stronger form of the enzyme were 3 times as likely to have Gulf War illness. So that covers presumptions for Gulf War illness, or at least what we're going to cover today. And there are other presumptive conditions. And one of those is amyotrophic lateral sclerosis, otherwise known as Lou Gehrig's disease. So that similarly is a presumptive condition where you don't have to prove that the condition was incurred during service, you don't have to present evidence. The VA will assume that for any veteran who had active continuous service of 90 days or more. And there's no time limit for when Lou Gehrig's disease becomes manifest. It can become manifest at any time after service, as long as you're a veteran who had active continuous service of 90 days or more and have a diagnosis of Lou Gehrig's disease. Now, another set of presumptive conditions are chronic diseases and tropical diseases. And we'll cover chronic diseases in a little more detail in a moment. But for most chronic diseases, if they become manifest to a degree of 10% or more within 1 year from discharge, and the same for tropical diseases, you will receive the presumptive benefit, meaning you don't have to present evidence affirmatively showing that the disease arose during service. Now, there are also presumptive rules for former prisoners of war, and the presumptive diseases are listed at section 3.309 subsection C. Now, there are a whole bunch of different conditions that are recognized as being presumptive for former prisoners of war. And some of these conditions actually require that the prisoner of war was held for 30 days or more. And like I said, we're going to talk a little bit more about chronic diseases because some of these are really important to consider when you're filing a claim for a veteran who was recently separated from the military, because as I said, for the most part, they must become manifest to a degree of 10% or more within 1 year. So you're really talking about the veterans who were recently separated from the military. And the list of chronic diseases is presented at 38 CFR section 3.309. And like I said, must be manifest to a degree of 10% or more within 1 year, except for Hansen's disease, tuberculosis, and multiple sclerosis. Those conditions have their own time rules. Now, one really important condition or chronic disease that is listed at section 3.309 is psychoses. And this can go a long way for veterans. Now, some of the psychoses that really stand out to me in talking about this are schizophrenia. And why that is important is because oftentimes, there's two reasons really. Oftentimes the VA, the Veterans Health Administration, does diagnose veterans with schizophrenia or schizoaffective disorder as a misdiagnosis. And there have been studies done that find that African American men are widely or highly disproportionately misdiagnosed with schizophrenia or schizoaffective disorder in the general population, and that also applies to the veteran population. So it is common to find that a lot of veterans are misdiagnosed with those two conditions, schizophrenia and schizoaffective disorder, and it's very hard to argue a misdiagnosis. So if those conditions present within 1 year, getting a veteran service connected for those conditions can be an option instead of trying to fight the actual diagnosis. The other thing to say about schizophrenia is a lot of military age service members around the age of 18 to 20 is when people usually experience their first psychotic break. So for somebody who is actually prone to schizophrenia or a schizoaffective disorder, that's when their first psychotic break is most likely to occur, is within that age when most service members enlist or are finishing up their service. So having that be able to be a presumptive condition within 1 year of separation can be really important. Now the next one is also very important, and that's bipolar disorder or manic depression. And we see a lot of veterans coming out of the military who are diagnosed with bipolar disorder and manic depression. And being able to service connect that as long as the diagnosis is made within 1 year, having it presumed that that was incurred during service is very important. The same for major depressive disorder, which is also enumerated in 38 CFR 3.309 under Psychoses, and similarly some personality disorders. So you can really, having psychoses covered under that section of chronic diseases where you get the presumption that the condition was service-connected as long as the disease was or is diagnosed within 1 year of separation. That's really an important section of the regulations to pay attention to for presumptive conditions. Now there are also presumptive rules for radiogenic diseases, and that's listed at section 3.309D. And this is for service members who were exposed to ionizing radiation, and then as veterans are making a claim for conditions that result from that exposure. Now they must have had on-site participation in a test involving detonation of a nuclear device. They must have, or participated in the occupation of Hiroshima or Nagasaki between August 6, 1945 and July 1, 1946, or had an opportunity for exposure while being held as a prisoner of war in Japan. And there's no time limit for one of the enumerated diseases to manifest. These presumptive rules, it can be really easy to overlook them sometimes when you're either doing a rushed intake with a veteran or just putting together a claim, you know, especially for the Gulf War syndrome. And, you know, a lot of veterans really don't know don't piece together the different symptoms that they have with the fact that they serve during the presumptive period, because the symptoms are so varied and amorphous. Fatigue, weight loss, etc., weight loss, weight gain. So it's always something that is good to check in about. If you see that somebody was, served during the presumptive period, and you notice in their medical notes documentation of those conditions, or just in your initial discussion with them, check for those conditions. Similarly, if you're going through somebody's records and you find that they checked off exposure to burn pits, check in about symptoms, or even just because of the prevalence of burn pits and particulate matter from industry, etc. Check in about potential symptoms, and definitely keep in mind I can't stress enough about keeping in mind the different psychoses that get the presumptive service connection if they're diagnosed within 1 year, because a lot of times you'll hear that a person has depression, and you won't think, well, that didn't, there's no in-service diagnosis, depression is hard to service connect, etc., and you won't think to file the claim, or but those service-connected presumptions are really, really important. So it's important to always keep these rules in mind when having discussions with veterans. So thank you very much for listening to this portion, and now I'll pass it over to Katie.
Kevin? Kevin?
Yes.
I'm not seeing the slideshow.
Um, you have it. You just go to slideshow. You're on view right now.
Under where?
Under slideshow up top, you're selected on view.
I see show my screen. Is it near there?
Yeah. Show my screen. Click the little arrow.
Yeah.
And clean.
Clean. It's checked.
There you go. You got the PowerPoint open. It says other presumptions.
It's not on my. Oh, is this? Sorry. Did it just change?
Yep.
Okay. Sorry about that. I'm ready. Hi, my name is Katie Dwight, and I'm going to continue on here and talk about Agent Orange presumptions. And it all started back in 1962 with Operation Ranch Hand. That was the name of the military operation that directed spraying of Agent Orange in Vietnam. And there were a number of, Agent Orange wasn't the only herbicide that was used. There were a number of them, and they were all referred to by a color. There was white and blue, and so they got the name rainbow herbicides, or the nickname. The program ran from 1962 until 1971, and it involved spraying an estimated 20 million U.S. gallons of herbicides over rural areas of South Vietnam in order to deprive the Viet Cong of food and vegetative cover. Some Agent Orange was also sprayed in Laos and Cambodia. Nearly 20,000 flights were flown during those years. And the flights were run by the aircraft C-123. And these planes were fitted with specially developed spray tanks with a capacity of 1,000 U.S. gallons of herbicides. And when a plane went out on the mission to spray, it sprayed a swath of land that was 80 meters wide. And it would be at a rate of 3 U.S. gallons per acre. Usually they sent out multiple aircraft, 3 to 5 airplanes flying side by side to cover the most area. It wasn't until later that Agent Orange was publicly suspected of causing widespread harm to human beings upon exposure. This ultimately led to the Agent Orange Act of 1991, which requires the VA to provide presumptive service connection for a disease if the Institute of Medicine of the National Academies shows a positive association exists between Agent Orange and a particular disease. And if the credible evidence supporting the connection is equal to or outweighs the credible evidence against an association, the VA must provide presumptive service connection. The VA now presumes exposure to Agent Orange for those veterans who served in Vietnam or the Korean DMZ and some who served in Thailand. To get the presumption of service connection for Agent Orange exposure, there are 3 requirements. This veteran must have served in Vietnam between January 9, 1962 to May 7, 1975, or along the Korean DMZ sometime between April 1, 1968 and August 31, 1971, or on certain military bases in Thailand during specified periods. That's the first requirement. The second one is that the veteran have a disease or a secondary disease to the principal disease recognized by the VA as being linked to Agent Orange to a disabling degree of 10% or more. For some of the diseases, the disease must manifest within a certain time period from the last day of Agent Orange exposure, but that's only a handful of conditions that have a time limit. So what is Vietnam service? It is active military, naval, or air service during the specified time period, and it includes service on the inland waterways of Vietnam and in the waters offshore, and service in other locations if the conditions of service involve duty of visitation in the Republic of Vietnam. And that language is directly from the regulations cited at the top, although it's somewhat misleading about the waters offshore, and I'll talk about that in just a minute. Those who served in boats on inland waterways of Vietnam are granted the Agent Orange presumption, and they're nicknamed brown water veterans. Then there's the blue water veterans. They have not been granted, they do not have the benefit of the presumption at this point in time. In the past, from November 1991 to February 2002, the manual M21-1 provided that anyone with a Vietnam campaign medal would receive the Agent Orange presumption. And during that period, VA granted some and denied some Blue Water Vietnam veterans the presumption. And it's interesting, a study by the Institute of Medicine, actually 2011 study, found they studied whether or how and how much might Blue Water Vietnam veterans have been exposed to Agent Orange. They found that there were several plausible ways by which Blue Water Navy veterans could have been exposed to herbicides, but the study concluded that there was not enough information for the IOM to actually determine whether Blue Water Navy personnel were or were not exposed to Agent Orange. So they ended up being inconclusive, or drawing an inconclusive conclusion. But whether it is possible to demonstrate that Blue Water personnel were or were not exposed to Agent Orange, and these are the questions they were answering, whether it is possible to demonstrate that Blue Water Navy personnel were or were not exposed to Agent Orange, and whether it is possible to state with certainty that exposure was qualitatively different from that of the Brown Water Navy and ground troop counterparts. The study found a number of limitations and uncertainties associated with the data. There was not a lot of data to review, not sufficient data. They found that ground troops and brown water veterans had more means of being exposed to Agent Orange than did Blue Water vets. Ground troops and brown water veterans could have been sprayed directly from overhead, have exposure to areas that had been sprayed, and contamination of drinking water through groundwater. Blue water veterans could have been exposed to spray drifting off the mainland and exposure from those who swam in contaminated waters. One exposure mechanism was specific just to Blue Water Navy ships, and that was exposure through drinking water, through the water distillation system. Ships created their own drinkable water by filtering seawater, but the process did not filter out Agent Orange. So if there was Agent Orange in the seawater, that would have gone right into the mouths of Navy veterans. But the IOM committee that did the study felt that the paucity of scientific data made it impossible to draw firm conclusions. And that's the most recent study on the matter. In 2006, the Court of Appeals for Veterans Claims held that Vietnam veterans who served in the waters offshore Vietnam were entitled to the Agent Orange presumption. But then the VA appealed, and they won. The Federal Circuit overruled the CAVC case and said that Blue Water veterans would not receive the presumption. Those who had received it in the past would not have it taken from them retroactively. According to the VA, there is no evidence to support claims of Agent Orange exposure based on loading Agent Orange aboard a ship for transportation, serving on a ship that transported, stored, used, or tested Agent Orange, or working on shipboard aircraft that flew over Vietnam and carried Agent Orange. because the VA denies that these are valid ways of exposure, the VA will no longer submit requests to the Joint Services Research Records Center, JSRRC, to research allegations regarding these methods of exposure. What they will do is place a memorandum in the claims folder of the veteran explaining that there is no evidence to support such a claim of Agent Orange exposure aboard a Navy or Coast Guard ship during the Vietnam era. Blue water Vietnam veterans do get a presumption that's unrelated to Agent Orange, but that's for non-Hodgkin's lymphoma. The VA often errs in not recognizing or forgetting about this presumption and not granting it. And in addition, they often forget about the other associated diseases that are also presumptive conditions, such as any lymphoma other than Hodgkin's disease. And these listed here on the slide. Errors by the VA in failing to service connect for these conditions are pretty common. A veteran must only prove that he or she set foot in Vietnam. It does not matter for how long. And a person aboard a Navy or Coast Guard ship that docked at a Vietnam port is presumed to have gone ashore. There's a list published at the website listed here of 330 inland waterway boats and naval and Coast Guard ships that stopped at Vietnam ports during specified periods of time. If a veteran alleges service at a different time, the VA is supposed to undertake an investigation to determine if the ship was there during the vet's time period. If a veteran alleges that a ship on which he or she served docked in Vietnam, but it's not on the VA ship list, the VA is required to request verification from the Joint Services Records Research Center. If the ship's official history does not support the allegation, JSRRC will review the ship's deck logs for the time frame identified by the veteran. And the VA is constantly adding to this list. Many veterans had permanent duty stations in other countries, Laos, Thailand, for example, but did step foot in Vietnam, which would give them the presumption. But it can be hard for these veterans to prove that that's what happened. Credible testimony under oath has at times been accepted by the Board of Veterans' Appeals, but you're better off if you can come up with morning reports or unit rosters or other evidence in your records proving that you were there. Those who served in the Naval Aviation Service, the VA is required to request veterans complete military and/or unit records from JSRRC, and they're also required to search the Dictionary of American Naval Aviation Squadrons for evidence. So in addition to Vietnam, the VA recognizes a presumption for certain units that served along the DMZ in Korea. There was an area 151 miles long by 350 yards wide that was hand sprayed with Agent Orange. Over 12,000 U.S. military were exposed to Agent Orange in Korea during the Vietnam era. The VA has a list of about 18 military units that served in the DMZ during the specified period. If someone alleges service there but was not in one of these units, the VA will attempt to verify by sending a request to JSRRC. VA also recognizes service and grants a presumption for certain people, certain veterans who served in Thailand. And that's for Air Force veterans who served at the Royal Thai Air Force bases of those listed there on the slide. Army veterans who served on a Royal Thai Air Force base who state they were involved in perimeter security if there is additional credible evidence. And veterans who served at a U.S. Army base in Thailand who are members of a military police unit and who state their duty placed them at or near the base perimeter. And of course the reason they're interested in the base perimeter is because that's where Agent Orange was sprayed. There's many other places that veterans claim, places where they claim they were exposed to Agent Orange. And there's a number of bases in the United States that the U.S. has acknowledged are places where Agent Orange was sprayed. But those bases do not get a presumption. Another place that veterans have alleged Agent Orange exposure is on the U.S. base in Okinawa. There's a vocal group of several hundred veterans who are claiming exposure there, that they handled Agent Orange or worked with Agent Orange or stored it, and allegedly a number of barrels were unearthed at the base in Okinawa. But again, the VA, the Department of Defense does not acknowledge Agent Orange there, and the VA does not recognize it. After the war, there were Air Force reserves from 1972 to 1982, about 1,500 to 2,100 Air Force reservists who trained and worked on C-123 aircraft that had formerly been used for spraying. Air and wipe samples that have been taken from these aircraft were positive for Agent Orange. In 2014, the VA contracted with the IOM to determine whether service members who worked on these aircraft may have been exposed to harmful levels of Agent Orange. The IOM found that while the evidence is limited, the data indicate that the reserve members could have been exposed through multiple routes, and some reservists quite likely experienced non-trivial increases in their risks of adverse health outcomes. Now, this study just came out in January, and the VA has 60 days to respond to the report. Up to now, it has taken the position that there was not enough Agent Orange residue to be harmful, although at least one former Air Force reservist has succeeded in winning service connection, being granted service connection based on his service after the war on C-123 aircraft. But that's the exception to the rule. So, as I said, the first requirement for the presumption is service in Vietnam, Korea, Thailand, or Thailand in the designated areas and times. So moving on to the second requirement is to have medical evidence that the veteran has a disease associated with Agent Orange exposure. And the list of diseases appears at 38 CFR section 3.30 subsection E. And the third requirement is that it have its onset during the specified period. But as I mentioned, Not very many have a limited time period. Secondary diseases and conditions also qualify for the presumption. And there are a lot of secondary conditions. Diabetes, for example, has quite a number of conditions that are secondary to it, including neuropathy, eye conditions, blood sugar conditions, hypertension, heart attack, coronary artery disease, stroke, and skin conditions. So I want to tell you about the most recent Agent Orange study out of the Institute of Medicine. And they conduct studies every 2 years. And the most recent was in 2012. It actually was issued in December 2013, but they call it the 2012 update. And by statute, when the VA determines that a positive association exists between exposure of humans to Agent Orange, VA will publish regulations establishing presumptive service connection for that disease. A positive association means that the credible evidence for the association is equal to or outweighs the credible evidence against the association. The VA reviews studies every 2 years in issuing their updates. They review studies that have come out within the last 2 years. And they look at ones that report a positive relative risk and studies that report a negative relative risk of a particular health outcome. The VA then determines whether the weight of evidence supports a finding that there is or is not a positive association. If the VA determines that a presumption of service connection is not warranted, the VA must publish a notice of that determination in the Federal Register and include an explanation of the scientific basis for the determination. It's through these reports that the VA has elected to service connect 14 categories of disease. In the 2-year period since the last biennial report, the Institute of Medicine evaluated 6,800 studies. Unfortunately, there were no studies of Vietnam veterans. Some of them were occupational, for example, studying farmers who spray herbicides on their fields, or environmental, such as the study of cancer incidents in people who live near the site of an industrial accident in Italy. The IOM places each studied disease or condition into one of 4 categories: sufficient evidence of association, limited or suggestive evidence of association, inadequate or insufficient evidence to determine whether an association exists, and limited or suggestive evidence of no association. The VA usually grants the presumption of service connection or establishes that presumption for those diseases that fall in the top category, sufficient evidence of association. And they have established service connection for most of the conditions that fall in the limited or suggestive evidence of association category. In the most recent study, a couple of conditions were placed in the limited or suggestive evidence of association category, and those were hypertension, stroke, and spontaneous abortion. Hypertension was in this same category 2 years earlier. The IOM found no new studies on Vietnam veterans since 2010. They basically only found one study that they really felt was one that they would that they thought was weighty and valid. And the study seemed to have mixed results. So the VA maintained the assignment to the limited or suggestive evidence of association category. And the VA decided not to establish a presumption for hypertension. The IOM also studied strokes, and they moved it from the insufficient evidence to determine whether an association exists to the limited or suggestive evidence of association category, so it moved up one. And again, there were no Vietnam veteran studies since 2010. There was one study that they liked that was from Sweden, studying Swedish who were exposed to industrial chemicals. And this study evidenced a fairly strong connection between chemical exposure and risk of stroke. Other studies found no statistically significant connection. And the VA chose not to add a presumption for stroke, citing weaknesses in the Swedish study. There are 27 conditions from the 2012 update that the VA chose to leave in the inadequate or insufficient evidence category. These include reproductive dysfunction, respiratory disorders, hearing loss, eye disorders, and bone conditions. The IOM found that studies conducted since 2012 on these conditions were not determinative. So the conclusion of all of this is that there's no new presumptions from the 2012 update. So now I'm going to talk a little bit about Nemer the case of Nemer v. the Veterans Administration. And I'm going to talk about it and how its effect on effective dates. So for decades, the VA claimed that the only condition caused by Agent Orange was chloracne. In part due to the Nemer lawsuit, the VA was forced to acknowledge other diseases and cancers that result from Agent Orange. The lawsuit resulted in a stipulation and court order in 1991, and the VA agreed that it must identify all Vietnam veterans and survivors who applied or who had applications pending for service connection based on a new disease between September 25th of 1985 and publication date of the regulation adding the disease. They would redecide whether benefits were warranted for that disease under the new regulation after allowing the veteran to add new evidence. And if service connection is granted, the VA would apply special effective date rules. So these are major reviews that the VA did where they had to go back in time and review claims to see if there were veterans who had been denied who now under the new rules would be granted. And this is just a list of them. In 1991, for instance, non-Hodgkin's lymphoma and soft tissue sarcoma were added.
Katie.
Yes.
Kevin, your screen has been showing in the full PowerPoint, and it's not been on slideshow. So the edit's been recording.
So what do we have to do? Start over?
Yeah. I need to go down and show you real quick. Just leave your screen and I'll be down there in a sec to show you how it looks.
automatically, it has to be, it's right here. Like when it went back to this screen, it starts showing this screen. So when it transfers here, and then it went back here, and so it starts picking up all this, and then like when it was on that slide.
So I was lying on the floor at legal, trying to maintain his attention. Were you? I'm sorry. Were you trying to make attention? It didn't happen. Yeah. Oh, good. Okay. I need to. Oh, she's gone. Oh, no. Not you know, how to. We first here tomorrow. I can't find them when we return to work in the center. Have a take your phone? You don't have it in your email? I didn't send my name. No. It's on, because it was on my private text. Wouldn't it be on that? No. Well, I have a copy of, well, I might, I still have a copy of it in whole, but I found one that's stuck in storage. So I either for the storage, it's harder to open. Well, I feel like I'm like in storage because it's the file. It's in storage because it's fireproof. So, you know. Yeah, but I get, you know, they won't send that to you in email because it's a duplicate. I think it was a really crappy conversation. So now I have to. Yes, I know. Yeah, but if I leave tomorrow by 2, I won't get there before the medical secretary's closed. My appointment's at 5:15. And they close, the medical secretary closed at 5. Well, you can just go to the medical secretary anytime. Well, I come 9 to 5, you know, their office is locked in. Oh, yeah, you just walk in. All right. I'm going to do that. Okay. Yeah, oh, yeah, I can take it. Okay. No, no, no. Oh.